Your home is your biggest asset, and it's one of the most expensive things to either buy or sell. Today, I'm here with attorney Zack Sims, and he's going to be reviewing the top 5 things to consider from a legal perspective when you're buying or selling a house. The first thing we have to think about is the attorney review period. So Zack, can you take a couple minutes and just kind of tell us about attorney review and how that works from a contractual perspective?
Sure. That is the first step in the path towards navigating your way towards a closing and actually selling your house. As soon as I get a contract, the very first thing we have is the attorney review period. It starts on the date of acceptance and it goes for 5 business days.
But it can be extended if it needs to go longer.
Absolutely. And that's something that happens from time to time. It's not at all unusual. During those 5 business days, both the buyer's attorney and the seller's attorney are going to propose modifications to the contract, things that help remove ambiguities, make things a little bit more crystal clear, and each attorney will propose those modifications to benefit their client and protect their client as best as possible.
Oftentimes, I'll have clients that are attorneys, and they want me to make changes to the real estate contract. Real estate agents cannot make changes to the real estate contract. We are not attorneys. We cannot act as attorneys. All we can do is basically fill in the blanks. So I always tell my clients, this is when you have attorney review period, that's your chance to have the attorney modify the contract as you wish.
For a real estate agent to modify the contract would technically be considered practicing law without a license. So that's something illegal. So you do want to avoid that. However, having said that, it's not a bad idea to get the attorney involved in the transaction even before there's a contract.
Quick call,
quick email. Hey, we have a question. There's an issue that's unique to this particular transaction. Should we put something in the contract now up front so that it's clear to everybody going forward? And that's always a good thing to do.
And I oftentimes will have clients that want their attorneys to see the contract before it's signed. It's not necessary, but if it makes you feel better, we can certainly do that. So attorney review. So what else is imperative? We've got 5 business days or extension of that.
Correct. It doesn't end after 5 business days. During attorney review, as long as the attorneys get their attorney review letter out to the other side before the end of 5 business days, then the parties have an unlimited amount of time.
Anytime during attorney review, either party can cancel. And so we definitely want to get through attorney review as expeditiously as possible.
But you never want attorney review to linger on and on and on. The longer it goes, the more doubtful the outcome of the transaction will be. But when I say that attorney review is unlimited, it's unlimited in the respect that the contract is not going to terminate on its own simply by the passage of time. Having said that, both parties want to work as diligently as possible to finalize all issues and move forward with the transaction.
So as part of attorney review, then we have the inspection. A buyer has a home inspection. There's issues that arise during the inspection. And technically and legally, all of the requests for the inspection, whether it be repair or a credit, have to officially go through an attorney. Can you kind of explain that a little bit?
In addition to the attorney review letter, or as part of the attorney review letter, the buyer's attorney will raise home inspection issues. These are issues that came up during the inspection where the buyer is either asking the seller to make certain repairs or to offer a credit in lieu of those repairs.
What inspection issues are actually permissible per the contract to request?
Sure, and this is very important because not every matter that comes up in a home inspection is permitted to be requested as a home inspection issue. The contract is very clear that in order for something to be deemed a true home inspection issue, it has to be a major component of the home that is not operating for the purpose for which it is intended. And minor repairs and routine maintenance items are not considered defects, nor are matters of a cosmetic nature considered defects under the home inspection contingency.
And obviously, safety and health also plays a factor in that if it's a safety or health issue.
Correct. Even if it's a minor issue like an outlet or an exposed wire, something that could be easily repaired, because it's a safety issue, is a legitimate request to be made during the home inspection period.
And how do you typically handle that? Do you see a combination of repairs made and a credit given, or do you prefer one over the other?
I tend to prefer my clients receiving a credit when they're buyers.
Or the seller giving.
Or the seller giving a credit for several reasons. First and foremost, it's problematic, it's burdensome, it's troublesome to have all the contractors come out to the house, start making the actual repairs. It takes time.
Yeah, sometimes there's not enough time.
Sometimes there's not enough
Closing's
time.
approaching, you can't get the guys in there fast enough to actually do the work.
And a lot of times these contractors are very difficult to line up. They're tough to book. It's just much easier, and it keeps things moving quicker towards closing if we offer a credit or accept a credit in lieu of those repairs.
Now, from a liability standpoint,
That's a big issue. Yeah. So when you're the seller and you take it upon yourself to have repairs made, you are liable for those repairs. And if they are done negligently and they cause damage or cause injury, you could potentially be liable for negligent repairs. When you offer the buyer a credit and the buyer accepts the credit in lieu of those repairs, there's no further liability that attaches.
right. And from a buyer perspective, then you can get things done the way you want to get them done, and from the tradesmen or the professionals that you choose.
I also think that's also important is when you accept a credit and you take it upon yourself to have those repairs made after the closing, you're overseeing the work that's being performed. You have the relationship with the contractor.
Yeah.
If you want to go above and beyond and make additional repairs, you can do that. And so I think that's beneficial for buyers.
Then the third thing is appraisal. And this has been a really big deal in the last few years where we have seen property values skyrocket. When appraisals are conducted, appraisers pull data from the MLS for homes that have closed within a 1 mile radius, sometimes 2 miles if they have to go out a little further, within 1 year. Property values are skyrocketing. Oftentimes, the appraisal might not come back because it's not reflecting these increases. Can you speak to that?
Yeah, that's a big obstacle to overcome in the real estate transaction.
A couple of years
Especially over the last several years, appraisals can be all over the place. And it's become common practice over the last several years that during attorney review, the buyer's attorney will make the contract contingent upon the property appraising at the sale price, at the contract sales price.
Right.
Now, if it does not appraise at the contract sales price, that does not necessarily mean that the transaction is over.
Right.
Typically what happens at that point is the buyer's attorney will reach out to the seller's attorney. Another round of negotiations. The buyer's attorney will indicate that the buyers can't afford to pay the contract sales price. They could only afford to pay what the property appraised for.
Say you have a home with a sales price of $500,000, but it only appraises out at $490,000. The buyers would then need to come to the table with an extra $10,000, which they may not have.
That's correct. And so the buyer's attorney would reach out to the seller's attorney and say, can we reduce the sales price to $490,000, the appraised value? And again, there's some back and forth here. So the seller's attorney would typically say, hey, if we could agree to reduce the sales price, maybe not all the way down to $490,000, maybe meet in the middle. If there's a resolution, great, the deal moves forward. If there's no resolution, the contract can be terminated and everybody has to start over.
What percent would you say of contracts are actually terminated because you can't come to an agreement on an appraisal issue?
Very few, very few. If it's a very unique home, and using the number of 500,000 in your example,
Easy math.
if the property appraises at 490, 495, that situation is going to resolve itself and the parties will reach an agreement.
Right.
If that same property only appraised at 400,000 or 425,
Even.
or even 450,
50,000.
that's a very large gap.
Right.
And that might result in the termination, but that's pretty rare.
And one other thing to consider as a seller is if the home doesn't appraise out now, it's unlikely it will appraise out with another buyer. So your choice is to either take the current deal with the current buyer or only look for a buyer that is willing to pay cash.
Correct. And the cash buyers are also pretty rare, pretty unique. So that's just something that you have to get together with as a seller, with your team, your professionals, have a good, honest conversation about what the house is worth and what it should sell for. And then you negotiate from there and hopefully reach a resolution with your buyer.
The fourth thing we need to consider is title and having a clean title. Can you explain what that is?
When you own a home, you have title to the home. And there are things that could adversely affect title to your home. Things such as liens, judgments, unpaid tax bills, unreleased mortgages, bankruptcies, divorce proceedings, estate proceedings, probate matters. There's 100 things that could adversely affect title to your home. So Illinois is a seller selection state for title insurance. So the seller's attorney will be the individual who orders title insurance, receives the title search package, and goes through that to clear title to make sure that there's nothing that would adversely encumber title or appear on title.
Because title is associated with the house, is that right?
That's correct.
It goes along with the house. So a buyer needs a clean or clear title at closing.
You cannot sell your house subject to liens and judgments and unreleased mortgages and unpaid tax bills. The buyer will never agree to accept title that way. So the title search is ordered and performed, and title is cleared by the seller's attorney, and it'll become apparent early on in the transaction if there are any adverse encumbrances, in which case the seller's attorney is going to get together with the sellers, and they're going to figure out how to resolve those issues so that you could convey clean title to the buyers at closing.
And then lastly, point number 5, a clear to close. What does that mean?
That means everything.
That means everything.
That is what we refer to as an unconditional loan commitment that the buyer receives from the buyer's lender. That's the lender's blessing. You are now clear to close. You could go ahead and schedule the closing, and the loan will be ready at the closing table for the buyer to sign and for the deal to be funded.
And how far in advance does that actually come to the, prior to the closing?
It used to come weeks and weeks in advance of the closing many years ago, and now the lenders have tightened up quite a bit. It's not at all uncommon for the buyer to get a clear to close 2 or 3 days before the closing.
Wow. Okay. What if it's a cash deal?
On a cash deal, we don't have to worry about a lender. There is no clear to close. Once you get through home inspection and you clear title, at that point you could schedule the closing and the transaction will close.
So clear to close comes from the buyer's lender. So to recap, the 5 things we reviewed today with attorney Zack Sims is the attorney review period and what that means, a home inspection, an appraisal, a clear title, and a clear to close. Any other wisdom you'd like to impart on us, Zack?
Best piece of advice I could give, surround yourself with a team of professionals that have a lot of experience doing this type of work. We've done it for years and years and years, 20 plus years together. And I don't want to say we've seen everything, but we've seen pretty much everything.
90%, probably,
Yeah.
right? We get to the closing table probably 90% of the time, which was a pretty good stat.
Yeah, we've had a very good success record, a very good track record of getting to the closing table and getting our deals closed. But it is so important to have a good team of professionals with a lot of experience behind them because we've seen all these issues. They've come up numerous times, and we've dealt with them and we've resolved all the issues. And we get to the closing table.
So thank you so much for joining us and imparting all of your knowledge. If you'd like Zack's contact information, please reach out.